President Peter, fellow Rotarians, it's a great honour and privilege to be standing here to introduce our speaker, the Honourable Christopher Finlayson QC. Chris is the Attorney General, Minister for Treaty of Waitangi Negotiations, Minister in charge of the New Zealand Security Intelligence Service, Minister responsible for the GCSB, and he's also Associate Minister for Maori Development. And for 6 years in this government, he was the Minister for Arts, Culture and Heritage, where many people thought he did a much better job than his predecessor. But I'm sure he'll tell us more about that shortly. Chris is a very long-term Wellingtonian, born and bred here, educated at St Pat's in town and Victoria University, and has worked as a lawyer and barrister here throughout his career before going into politics. And in politics, he's been a very strong champion of Wellington issues. He's also been a strong supporter of this club and was the keynote speaker, I believe, last year at the Rotary Forum, speaking on privacy and security. Minister, we're delighted to have you and look forward to hearing from you.
Well, thank you, Charles. That's the nicest thing you've ever said about me. Normally, when we're on the golf course, he's downright insulting, and he's always criticising me for being too slow on the course, but there you go. Look, I really am very pleased to be here. There are so many people I could acknowledge because I know them. I acknowledge the ambassadors. Great to have you here. They are both outstanding representatives of their country. And can I acknowledge Stuart Brooker above all, because Stuart may not realise it, but he did the best turn that anyone's ever done for me, of anyone in this room, apart from Charles when he gives me very generous putts. And Stuart, many years ago, ran a company called Brooker and Friend. They were legal annotators. They were also the authors of Adams, Criminal Law Practice, Anderson Company Law, and he decided in the early 1980s that they'd write a book on civil procedure, and he commissioned Robert Andrew McGeckin, as he then was and now is, to write the book, and Stuart asked me if I would help. And I remember spending weekends on it, Stuart, and holidays and all sorts of things, and my colleagues at Brandon's thought I was a bit peculiar to do this until the first royalties cheque arrived, and then David Howman said to me, actually that's partnership property, and he got as much respect as two exquisitely positioned fingers permitted, and I've kept those royalties, and you've got to give it to Stuart. Above all things, he's a great payer when it comes to royalties. So I acknowledge Stuart and thank him very much for facilitating my numerous overseas holidays. This is a very interesting period. Do I say I enjoy campaigning? The answer is frankly no, but it is good to get out and meet people. Sometimes you're very surprised by the people you meet. The other day, and Denzel, you'd be interested in this, I went to the Year 13 retreat of my old school, St Pat's College in Wellington. It was being held at the Pines, about 130 kids, and the speaker before me said to everyone, well, close your eyes, and of course I didn't, because I wanted to find out the answers to the questions. How many believe in God? And 60% of them put their hands up. How many don't believe in God? About 30%. How many don't know? About 10%. And I said to myself, what are they going to St Pat's for? But that's, I guess, the way. I've got nothing, I hasten to add, against those who do not believe in God, or even people who are Anglicans. But I have to say I was rather taken away at the response, and it makes you wonder just whether the kids, Joe, should go to Scots. So I'm very pleased to talk to you today about a subject which is dear to my heart, namely treaty settlements and the sort of work I've been doing over the last 9 years. I've been so very grateful to Sir Anand Sachinan, for example, who's helped me on a number of things, I don't think there's anyone else in this room who's done any work for me, but there's always a first time if I get the portfolio again if we win. But it has been a very interesting piece of work, and I have so enjoyed the foreshore and seabed debate, which I think, in fairness, has now come round to my way of thinking. Famous last words. I know there are a few people who are kicking up a bit of a fuss about favouritism to iwi and to Māori generally, about being able to make a claim, but it is useful just to traverse very briefly that story. That in 2003 the Court of Appeal came out in the Ngāti Apa case and said that people had the right to take their case to court, and it didn't say what customary title would be were they successful, and it didn't spell out what the tests would be, and that particular result was legislated away. And when we came into government, we said that we'd take a fresh look at it, and I was always very firmly of the belief that it was a rule of law issue, that people had the right to go to court. They didn't have the right to win, but they had the right to go to court, and one law for all meant that that had to be restored. And I always recall a very interesting email exchange between Don Brash, who's been rather vocal on the issue, and the late Roger Kerr, who was head of the Business Roundtable as it then was, and Roger was blind copying me in on some emails he was sending to Don, and Roger actually was my inspiration on this matter, because he said, Don, this is a rule of law issue. Let the cases go to court. The courts will sort out the wheat from the chaff. If there are results that require a political negotiation, well, so be it. But it's very important, both on rule of law and property rights issues, to be respectful of this. Sadly, Don didn't listen and has gone down a different path, but I've always maintained Roger was right on that issue, and on many other issues, frankly. And so that's what we did. We put the legislation back into place. We gave people the right to go to court, and we put a limitation period on it, and the limitation period expired earlier this year. And that's why we had quite a number of cases which were filed in the court, many of which were not complicated by any vestige of merit. Many of them are hopeless. Anyone who lays claim to anywhere around Wellington Harbour, good luck to them, because they would have their forebears would have had to have been Freddie the Frogman in 1840, given where the seashore was. I just don't see any prospect of success, but there are parts of New Zealand where there is customary title, and they'll have to go to court and prove their case, and will have to prove that they've had exclusive use and occupation since 1840 without substantial interruption. And as I say, good on them if they can prove that. And so there's only been one case in the High Court to date. There will be some other cases. The late Roger Kerr is right. The wheat will be sorted from the chaff, and it won't be the end of the world. And customary title is not the same as freehold title. It's a lesser title, can't be sold, and can be inherited, and public access is guaranteed. And I know that there's been a bit of noise on the subject recently. I know people have been getting uptight. But the fact of the matter is, I think that apart from one or two parties, there's a broad consensus that it was right to repeal the foreshore and seabed legislation, right to give people the right to go to court, and to spell out what customary title is and the test for obtaining it, because I did not want the courts to be sitting on those matters for 20 years and then coming up with some, with the greatest of respect, ropey decision. So that's where we are there. On the treaty front, I've had a lot of interest and fun over the last 9 years. I think it would be dangerous to look at the success of treaty settlements by looking at Wellington, because Wellington, I have to tell you, is a very disappointing place. If you want to see treaty settlements not working, then go out to Shelley Bay, because that land was handed over in 2009 and nothing's really happened, and what they're proposing out there, frankly, I think is a bit disappointing. The Wellington settlement hasn't succeeded because of various reasons. It's probably best that I don't go into too much detail there, but Phil Barry, a noted economist, wrote a review of the success of treaty settlements around the country. All of them were positive, with the single exception of Wellington, frankly. So it requires new leadership. It requires really starting afresh. And I hope they get on with it sooner rather than later, and I hope they do a good job around Shelley Bay, because it should be one of the jewels in Wellington's crown. But elsewhere around the country, very good progress has been made, and let me take you on a little cook's tour of the place. The South Island is now completed, apart from one small issue relating to what they call the SILNA Act, the South Island Landless Natives Act, one of the most pernicious pieces of legislation that Parliament ever passed. Basically, what it meant was that people in Ngāi Tahu and the iwi at the top of the South Island had their good lands exchanged for landlocked land on Stewart Island and other such places, basically ripped off. And what we have to do is try and sort out who are the living beneficiaries under the SILNA Act. And, well, my view is I'd do a swap. I'd take back that landlocked land, which is useless and worthless, and I'd give them some other Landcorp farms or something like that. But that's the South Island dealt with, and 21 November 1997, I remember it well, at Kaikoura, when Jim Bolger signed the deed of settlement with Tipene O'Regan. And the fact of the matter is that Ngāi Tahu have done so very well over the last 20 years and are playing a major role in, for example, the rebuilding of Christchurch. Over on the Chatham Islands are very interesting. It's part of the Rongotai electorate, and my colleagues tell me to stop going there because I seem to come back with bills for a new wharf on Pitt Island that Cyclone Pam promptly damaged. $55 million for rebuilding Waitangi Wharf. The airport needs strengthening so that the Convair can be replaced by a 737 Combi. But there are, probably most of you know the story on the Chathams. I've signed an agreement in principle with Moriori. Mutonga are a little bit behind, but progress is being made there. Up the east coast of the North Island, Rangatane in the Wairarapa have signed their deed of settlement, and their legislation's gone through, just about ready to sign a deed of settlement with Ngāti Kahungunu, including over Wairarapa Moana. And then up the island, pretty well everything's done up there, apart from a small dissentient group on the outskirts of Gisborne. Come round into the Bay of Plenty, just signed terms of negotiation with Te Whānau Apanui around Te Kaha. Ngāitai still got a wee way to go, signed an agreement in principle, John Luxton with Whakatoa the other day for $100 million, and that relates to a potiki. Into the Bay of Plenty, a lot of that has been done. There are still some overlapping claims between the Tauranga groups and the Hauraki groups, but we've made very good progress there. That great iwi of the central North Island, Tūwharetoa, has been signed up. Ngāti Raukawa around Takaroa has been signed up. Most of the Waikato is done. Into Auckland, most of the Auckland iwi are now, I was going to say settled, but some of them are very unsettled because there are always overlapping claims, and overlapping claims are the bane of my life. Into the far north, most of them are done except for Ngāti Kahu, which is led by an academic called Professor Margaret Mutu, who I think prefers to sit in her office and write about grievance rather than overcome it. And then there's Ngāpui, which will go nowhere until there is a change of leadership, until there is because some of the people there, in my line of business, we're dealing with iwi, you either get on with it or get lost. Some of them are not getting on with it, but they haven't got lost. So that's a process that needs to be worked through. And I talk to people, Ngāpui, as you could imagine, it being 130,000 people, has got some outstanding leaders, or people who with Ngāpui descent, like Ralph Norris, or Peter Cooper. And I said to Peter Cooper, why don't you get involved? He said, oh, they can stew in their own juice. So there's a way to go there. But when certain people go, that one will come together very quickly, and so it should, because it'll be a massive settlement, and there are so many issues up there that need to be addressed. come down into that beautiful King Country area. I signed an agreement in principle with Ngāti Maniapoto just before Parliament folded, $165 million going into that area. Fantastic opportunities there. Come into the Taranaki and all settlements are there except for the Ngāti Maru out of Stratford. All the others are done. And we also have to address the issue of the mountain, and I'll come back to that in a minute. And one of the highlights of my life, I have to tell you, was to go to Parihaka with Andrew Little, the then leader of the opposition, Jim Bolger, former Prime Minister, a whole swag of members of Parliament. The Chief Justice came along to sign an accord with Parihaka. For those of you who don't know the story, do acquaint yourselves, because it was a blot on New Zealand history, and it needed to be addressed. And after all those years, we reached a stage where we could apologise to Parihaka and have that apology accepted. Others have tried, but we'd reached a sufficient state with treaty settlements in the region, I think, it was the right time to proceed with that. And the only jarring note was I always receive unpleasant letters from people from time to time, but I received a number of letters from people after that asking me for chapter and verse on all the rapes that had occurred, and I found that profoundly distasteful. But anyway, we got there, and you know, you can go right around the country and people will talk about Parihaka, because they know that it was an important event in New Zealand's history. Jim was there with me. Jim's a very dear friend, and he told me that he and Joan grew up not far from Parihaka, and they never once heard the story when they were growing up. So that's why I personally think it's so important to get out there and teach New Zealand history. When I was in my last year at St Pat's, I was very lucky to learn about the Stuarts and America between the centuries, you know, such giants as Warren Harding and Calvin Coolidge. But I have to tell you, I think that I would have profited more from studying New Zealand history, but politicians can't set the curriculum, teachers do, and that's the way it has to be. But I would certainly think that the time is coming when New Zealanders should be learning about their own history, because above all it's so interesting, as the London Review of Books said once when reviewing one of Jamie Bellich's books on New Zealand. So that's another one that, if you're looking at highlights over the last 12 months, another real delight was legislating for the Wanganui River. And what we did with the Wanganui River was provide that the river owns itself. And it sounds a rather weird concept, and the river is represented by 2 representatives. But I was being interviewed by The Economist on the subject a couple of months ago, and a woman who was interviewing me said to me, "Oh, are you aware about what a court in India has just done the other day in relation to the Ganges and Yamuna rivers? They've given them the rights of a person." And so all around the world there are different ways of dealing with things, but and there are very common things, and quite, although I do have to say the court in India had referred to the Wanganui River example. So while on the face of it may seem nutty to give legal recognition to a natural resource, actually it's not all that strange when one analyses it, and corporate form or legal personality are quite useful tools when dealing with those issues. And there's a lot of work to do on the Wanganui River. Basically, it'll never be fixed up until somehow the Tongariro power development is altered, but that remains to be seen. And we did a similar sort of thing in relation to the Uraweras with Tūhoe. Last week, they wanted me to go up because they were launching their conservation plan for the Uraweras, and I had the great pleasure of flying over the Uraweras, and just, if you've never done it before, it's an unbelievable part of the country. It's probably, Rob, just about as big as the Netherlands, actually. It is a massive former national park. It should never have been a national park, because it always really belonged to Tūhoe, and public access guaranteed, and Tūhoe are going to manage the show with a majority of board members, and I can tell you now, nothing will change. Well, no, one thing may change. When people go into the Uraweras, I hope that they're not going to be monstered like they have been in years gone by, because people inadvertently have been trespassing on Tūhoe land. So a very positive, bipartisan, intergenerational piece of work. John Luxton was in Cabinet when this work started, and I think we can be very proud we're making good progress, and indeed if you get through the remainder of the work which is currently on the books with the Office of Treaty Settlement, there are going to be 6 more negotiations to get underway, and then that's it. And then we've been through it. But we have to be careful that we don't allow relitigation. I have had a concern about the issue of water taxes and paying royalties to Maori. If you pay a royalty, then it's a sign that there's some kind of economic interest or property interest. And it's no good to say, oh, we'll only pay it prospectively, because there'll be people who will stand up and want it paid retrospectively. So that's an issue I wouldn't go there myself. And what I have always done, be it the Rangataiki, the Kaituna, the Manawatu, whatever rivers, always involve people in the co-governance of the show, but do not allow any question of ownership of water to arise. Water is owned by no one, and if you start to get into property rights in water, then I think it's a very serious problem. So that's me. My task was best expressed by Paddy Gower some years ago when I was appointed Minister in charge of the GCSB and the SIS. He said, your job is to make this particular area boring. And I have succeeded, I would hope, beyond, unless something goes wrong, I've succeeded beyond my wildest expectations. So thank you very much for the opportunity to speak.
We've got time for a couple of questions. John.
That was excellent, Minister. Would markets help the water allocation issue, though? Because I'm thinking back to the comment that who owns water? Well, if we rely on markets, there has to be some kind of structure around dollars in that case.
Yeah, it could do. I know that that's one of the issues that's been looked at, but I'm so terrified by the prospect of people saying if you have tradable rights or whatever, you're into property rights type issues, that I do get very nervous about it, frankly.
Minister, there was a top-up provision that I knew south. Has that been implemented, and will it apply to all current negotiations? And is there a benchmark? Minister Graham at the time said $1 billion, I think, was the,
yeah.
There was a top-up after that. Where does that stand at the
Yeah,
moment?
John would know better than I would, because it was September 1992. He would have been in Cabinet. $1 billion in 1992 was fixed, and it was agreed that if that 1992 figure was breached, then there would be the top-up payments for the 2 iwi that were the first out of the blocks to settle. And so that figure was breached a couple of years ago, and it is reflected in ongoing arbitrations that we're having with Tainui and Ngāi Tahu to determine, and the arbitrator is Andrew Tipping, to determine what's in and what's out, what's properly brought into the equation, being a figure that goes towards a settlement or a non-settlement figure, and we're working those things through at the moment. I think by the time we settle in 2017 dollars, the amount which will be required will probably be close to $3 billion. And basically that's what Sir Graham Latimer prophesied years ago.
Thank you, Minister. I don't think we've got time for more questions. If I could call on... would you like to sit down? Thank you.
Minister, thank you for being with us today and for such a riveting tour of New Zealand and the treaty settlements. Congratulations on those successes, particularly those that have occurred in your tenure. I think you are the second longest serving Attorney General in New Zealand history, and you are the longest serving Minister for Treaty Negotiations, I believe, as well. Third longest? Third. Okay, I thought you were second. Oh, well, maybe you'll become third. And on that note, can we wish you all the best for the next week? We know it's going to be very stressful for you and other politicians, and should you be on the winning side on Saturday, it would be great to see you continuing on with the treaty settlement work, because you have 6 more to complete, and I'm sure you would be able to do so within a 3-year period. Can we acknowledge the Minister in the usual way?